So good day, Attorney DAMARIS. I'm Jacqueline Valle, a Bachelor of Science in Criminology student, third year from Section D. My question is, what is felony? Felony is an act or omission punishable by law, particularly the Revised Penal Code of the Philippines. Felonies are committed not only by the means of deceit or dolo, but also means of fault or culpa. Deceit or dolo is performed with deliberate intent. Ito yung mga krimen na nagawa dahil intentional or gusto talagang magawang krimen. Then we have fault or culpa. It is the opposite of deceit, which it is a wrongful act result from imprudence, negligence, lack of foresight, or lack of skill. Ito yung mga nagawang krimen dahil sa kakulangan ng alam. Then I will give the examples of felonies. It can be a murder, rape, burglary, and the sale of illegal drugs, and many more. Then we have two classification of felonies. First is the intentional felonies. Then the second one is the culpable felonies. When we talk about intentional felonies, or the number one, it is the act or omission of the offender is malicious. Meron itong deliberate intent at intention to cause injury sa ibang tao. Yun nga yung intentional. Halimbawa ay pagpatay sa biktima dahilan ng pagsiselos. Then we have culpable felonies. This is an act or omission of the offender in which not malicious, kabaliktaran ng isa. Ito yung tinatawag na unintentional, na pwedeng dulot ng isang aksidente. Halimbawa dahil sa kapalpakan or kulang sa alam. Culpable felonies, one example is car accident. Nadulot ng pagtawid ng biktima agad sa isang kalsada na naging dahilan sa pagkamatay nito. So, these are the difference between intentional and culpable felonies. Then I will also explain what is felony in direct participation. So, direct participation, these are the person who did the criminal act. Kung sa Tagalog pa, ay siya mismo ang gumawa ng krimen. Halimbawa sa kasong pagpatay, ito yung tao na mismo pumatay sa biktima. Or sa kasong pamumusil, ito yung persona na gumawa at gumamit ng paputok na nagdudulot ng isang krimen. So, these are the difference between the two. Therefore, felonies is an act or omission that punishable by our revised penal code. Thank you.
Good morning, everyone. I'm Joanne Zambrano. We talk all about what is felony. Felony is a serious criminal offense which under federal law is punishable by death or imprisonment for a term exceeding a year. Some example of felony, example, kidnapping, arson, murder. People have been convicted about felony is called felons. For another example, what is felony? A felony is a serious criminal pagkakasala, have a serious criminal offense or crimen. And that's all. Thank you.
By inducement is more likely giving a bribe or an incentive to make a person to carry out a crime. Ito yung way na ginagamit kung saan pinoprovoke nila yung person sa korte para kuin yung krimen na kahit hindi naman talaga nila ginawa. Pero kung gagamitin tong way na to, kinakailangan na sapat at malakas ang pinanghahawakan mong statement o bribe para hindi makatanggi yung taong ini-induce mo. Halimbawa, ito ay ang kaso sa movie na pinamagatang Miracle in Cell Number 7, kung saan isang tatay na may special condition sa pag-iisip ang naakusahang ng rape sa isang batang babae. At habang nasa kulungan siya at kasulukuyang pinaprocess yung kaso niya, may nagpuntang isang pulis ang kumusap sa kanya at sinabihan siyang may gagawin sa anak niya kung hindi niya akuin ang kasong hinaharap niya ngayon. Dahil doon, lumabas na guilty siya na kasong rape at napatawan ng death penalty.
Morning, ma'am. I'm Jose Luigi V. Paras, and I'm going to explain and give the examples of by the inducement. By the inducement, it said, or it means that inducement must be strong enough that the person induced could not resist. So, ang ibig sabihin nito, ito yung taong nagko-compel to induce the others. Parang tulad ng letter, kunyari, for example, si letter A, magulong kanyang isipan. Tapos si letter B, ito yung taong kumbaga parang hinihimok niya si letter A, at si letter C, sinabi niya si letter A na gawin mo yung bagay na yan, itry mo at sasaya ang buhay mo. Di niya alam na illegal pala yon, tulad ng paggamit ng drugs. So ngayon si letter A, ginawa niya ngayon dahil sa pagko-compel pag-i-induce ni letter C. So doon papasok ang by inducement. At saka yung when does principal inducement become liable? If lahat ng nandun sa crime scene ay gumawa ng krimen, matatawag nating principal by inducement.
Good morning, ma'am and classmate. My topic is principals by indispensable cooperation. Principal who cooperate in the commissions of the offense by another act without which it would not have been accomplished. Ang ibig sabihin po niyan, ang makikooperate sa paggawa ng krimen na kundi dahil sa kanila ay hindi maisatuparang isang krimen. Yan po ay principal by indispensable cooperation. May example po ako. Ito ay senaryo. Si X, A, B, C. Si X ay isang businessman at si A naman ay notorious killer, B ay isang target at si C ang gun owner. Si X ay inutusan niya si A na patayin si B. Si A agara naman humiram sa baril ni C, assuming na napatay na si B at nakita sa crime scene ang baril ni C. Ang tanong, sino ang principal by indispensable cooperation doon? Si C, dahil kung hindi dahil sa kaniyang cooperation, di mapapatay si B. Sa madaling salita, ang principal by indispensable cooperation ay pag-cooperate mo sa isang krimen na ikakatagumpay ng isang krimen na mangyayari. Yan lang po.
Good day everyone, I'm Robimel Elegado Videra from 3BSCRIM-D. Today I will going to discuss pro reo doctrine or rule of lenity or tinatawag ding in dubio pro reo. In English, when in doubt, the rule for accused. So, sa pro reo doctrine, sinasabi dito na kapag ang batas daw ay may dalawang interpretasyon, ang isa ay lenient sa akusado at ang isa naman ay strict sa kanya. So, ang ia-apply sa akusado ay mas lenient and favorable sa kanya. Dahil kapag may duda sa guilt ng akusado, kahit gaano kadami ang ebidensya mo laban sa kanya, siya ay dapat mapawalang sala.
Pag sinabing pro reo doctrine means law of lenity, and in English, when doubt, rule for accuse. So magbibigay ako ng halimbawa ng pro reo doctrine. Si Alfred, nakita niya yung tatlong magnanakaw na pumasok sa kanyang bahay. Yung dalawa, positibong namukaan niya. Pero yung isa, hindi niya namukaan kasi madilim na at yung likod lang yung nakita niya at ang pangangatawan. So kinabukasan, nakita niya yung dalawang magnanakaw na kausap si Allen. So kanyang pinagpalagay na si Allen yung pangatlong magnanakaw kasi kausap niya yung dalawang magnanakaw na nanloob sa kanila eh. So yun yung kanyang iniisip. So nung nasa korte na sila, tinanong si Alfred nung defense counsel na nakita niya ba si Allen na nanloob sa kanilang bahay kasama yung dalawa. Sabi ni Alfred, hindi niya nakita yung mukha. Pero kinabukasan, nakita niya na nag-uusap yung tatlo. So, kanyang pinagpalagay na si Allen yung pangatlong magnanakaw na nanloob sa kanila. Pero hindi niya nakita yung muka. So, depensa naman ni Allen, natutulog siya yung mga araw na iyon. At hindi siya yung magnanakaw. So, from his alibi, that is the weakest. Kasi natutulog lang daw siya. Pero, yun yung pro reo doctrine. Kung may pagdududa, kahit katiting lang, ay mapapawalang sala si Allen kasi may pagdududa. Yon ang pro reo doctrine. Basta may pagdududa, mapapawalang sala ang accused. Thank you.
Hi ma'am, I'm Tom Chris Verdadero from 3BSCRIM-D. Article 18, accomplice. Ang accomplice po ay tumutukoy sa any person basta di siya kasama sa Article 17. Example, si Juan may papatayin sa kabilang isla. Bago siya makarating sa kabilang isla, may dadaanan siyang malalim na dagat. Sa nasabing isla, si Pedro lang po yung may bangka. Alam ni Pedro ang pakay ni Juan sa kabilang isla. Subalit, nung ito hiramin ni Juan kay Pedro, hindi niya lang ito pinahiram ng bangka, bagkus binigyan pa niya ito ng baril. Ngayon, si Juan ay principal by indispensable cooperation at si Pedro naman ay ang accomplices.
Hi ma'am, good day. My name is JONALYN from BSCRIM COC 3 Section D. My task today is explaining the article and give an example of Article 18, accomplices. Dito po kasi yung mga taong there's an offense that they committed, may mga taong tumulong sa kanila para maging successful ang kanilang ginagawa, and then some of them are never caught before, they never caught, and then if there's accused caught by the police, they don't say anything about who's the person who cooperate for their offense. They are referred as accessories before the fact. For example of this as kidnap ransom, and then police arrested the accused who received the money from the wife of the victim, and then They learned the victim was kept in the house. Uh, when they arrived to a house, X and Y are the offender. The police calls them, and and also uh they help each other, and one of one of them are skip also, no, nakalayas na siya, no, lumayo na siya dun sa kasama niya din. Ang may marami pa silang kasama, pero hindi sinabi ng isang naaresto kung sino kasama niya o sino ang naging pero ang pera nadala na ng kasama niya, pero siya lang na nakuha. Hindi lang niya sinabi ang tunay na ah,
Good morning, Ma'am DAMARIS. I am Jessa Inanod, BSCRIM-D, and now I am reporting Article 19, Accessories. When we say accessories, it is someone who gives assistance to the perpetrator in the crime without directly committing it. Or sila yung pinapasa yung gagawing krimen. And when do we say that accessories is not criminally liable? Kailan natin masasabi yon? It is when the felony committed is light felony or hindi gaano kalala yung nagawang krimen. And when the accessory is related to the principal who will commit the crime. He is related as spouse, descendants, family, relative, like that. He is not considered as criminally liable unless the accessory himself is perpetrated in the crime or assist the offender to commit the crime. And when do we say that the man is not an accessory? Kailan natin masasabi yon? It is when the man don't know the commission of crime. Hindi niya alam ang commission of crime. And he or she participated in the crime as principal or accomplice or an accomplice. Hindi natin siya matatawag na accessories, kundi matatawag na natin siya na accomplice or the principal who commit the crime. Thank you, ma'am.
Good day, Ma'am Damaris. I am Sarah Tagus from 3BSCRIM-D, and my topic is Article 19, Accessories. In the revised penal code, Article 19, accessories are those who have acknowledged of the commission of the crime and, without having participated therein, either principals or accomplices, take part subsequently in the commission in the following manners. Any of the following manners. Number 1 is by profiting themselves or assisting the offender to profit the effects of the crime. Number 2 is by concealing or destroying the body of the crime or the effects or instruments. Therefore, in order to prevent the discovery. And number 3, lastly, is the by harboring, concealing, or assisting in the escape of the principal in the crime. So the topic here is saying accessories is only present after the crime is committed. My example is I was working in the grocery store, and I have a friend meron akong kaibigan. He was my closest, and I did share my working experience there, the flow in the how it works. And one day, the grocery store has been robbed, by 3 people. And without me knowing, it was my friend. One of them is my friend. So, the part here is after.
Good afternoon. Um, Based in my own understanding about Article 20, assessors who are exempt from criminal liability, there's a four principle: the spouse, ascendant, descendant, and legitimate adopted from brothers, sisters, or relatives that they are the same blood. Spouse is the meaning of spouse is it's like that it's ties blood of the family. The ascendant is it's part of the family also, and descendant it is the plants, persons, or containing relatives that involved. And legitimate is the rules and law that need to follow. For example, I am a police officer, then my brother committed a crime. We are the same blood, but we are not the same action. Yes, we are blood, pero I'm not committed in a crime. So, I should hindi ako ipapunish. Yung brother ko lang. So, accepted, like, oh, you are same blood, but I'm not committed a crime. My brother committed a crime. So, there is a difference between the two of them. That's all. Thank you.
Good afternoon, ma'am. I'm Jolan Kaminsi Quiring of COC, Pinma, Cagayan de Oro, BS Criminology, Section D. Today, I will make a short presentation or a simple explanation about decree penalizing obstruction or apprehension. Presidential Decree number 1829, penalizing obstruction of apprehension and prosecution of criminal offenders, is also called obstruction of justice. Its purpose is to discourage the indifference or apathy towards the prosecution and apprehension of
Good morning, ma'am. Good morning, sir. Here.
Good morning, everyone. My name is JONALYN and I'm here to discuss the PD 1829 with the Article 20 RPC. PD 1829, it is where they penalize the person who is willfully obstruct the investigations of criminal cases to the person who commit a crime. For example, destructions of personal records or documents of the person who commit a crime so that the police or the authorization did not recognize the profiles of the person who commit a crime. Baga parang pinagtatakpan ng isang tao yung nagawang krimen ng isang tao. Okay? Next is the Article 20. It is the exemptions provided for this article is based on the ties of blood. For example, is um, the person who are related sa kanila or dikit sa kanila, like siblings, yung mga kapatid, or yung asawa, or yung parents.
Good day, Ma'am Damaris and classmates. I'm Mary Rain C. Payabyab from section 3BSCRIM-D. So I will discuss the Article 20 or the accessories who are exempt from criminal liability and the Presidential Decree 1829. So, ano nga ba ang Article 20 or the accessories who are exempt from criminal liability? So, what makes someone an accessory to a crime? So, an accessory to a crime, it refers to a person who knowingly and voluntarily participates in the commission of a crime, as they assist or help another person to commit a crime, or they may have the same liability and punishment as the principal or the person who commits the actual crime. So, kailan na ang accessory ay exempted sa isang criminal liability? So, an accessory ay exempt from criminal liability when the principal is his spouse, ascendant, descendant, legitimate, natural or adopted brother, sister, or relative by affinity within the same degree. So, kapag kadugo niya, siya ay exempted sa criminal liability. So, kailan naman ang accessory ay hindi exempt sa isang criminal liability? Even if yung principal ay is related to him.
Good morning, ma'am. My name is Cindy Reyes from section 3BSCRIM section D. So, I will report for today is all about difference between accomplice and conspirator. So, bibigay ko lang yung pinagkaiba nila tapos pinagkamukha. So, sa aking pagkakaalam, may mga bagay pa rin na magkamukha si accomplice siya kasi conspirator. That means, alam nila yung mga purpose at ginagawa nilang crime. Yun yung pinagkamukha nila. Pero, once na sinabing conspirator, they themselves decide upon cause of action. So, sinasabi din na si conspirator is author siya ng crime. Kung saan siya yung nagsusulat or nagsasabi kung ano yung mga crime na yon. So, in short, author of the crime. Siya yung nagpapasya kung ano yung mga kailangan dun sa crime, halimbawa sa libro. Siya yung nagsusulat ng mga na-commit na crime doon. It means author of the crime. While the accomplice come to know about it after the principal have decided. So, si accomplice, masasabi natin na isa lang siyang instrument kung saan sa kanya is naka-agree na, may decide na, or may mga naganap na, or may mga decision na. So, kaya kapag sa conspirator, walang conspirator si accomplice dahil hindi sila part ng decision making. Nagaganap yung agreement kapag yung conspirator is tapos na niyang gawin yung mga ginawa niya. Kasi pag sinabi natin na conspirator, it means siya author of the crime Ibig sabihin, siya yung nagsusulat or gumagawa. While the conspirator naman, sinasabi lang na while the accomplice naman, sinasabi lang na isa lang siyang instrument kung saan meron ng mga decision making na nagawa doon, meron ng mga agreement or okay na, ganun lang. So, yun lang naman yung pinagkaiba ng dalawa na yun. That's all. Thank you.
Good day, ma'am. My name is Adrian Marquison, Section D. My topic is what is different between conspiration and accomplice. First, when we talk conspiration, is the criminal result not have occurred to reality to attach. For example, there are two friends have plans to steal in sari-sari store, but once again to do not commit or do the crimes, and accomplice means is the person who not being included principal the execution of the offense by previously act. Example is si Mark ay isang sundalo at si Kyle naman ay isang pulis. Si Kyle mayroong kaibigan na nangangalang Moy. Si Kyle naman ay gustong patayin si Mark dahil meron silang nakailitan or hindi ayos. At around in the morning, si Mark at si Kyle at si Moy ay nag-uusap dahil gusto nilang patayin si Mark. Si Moy naman ay merong baril na 45 pistol. At around 8 o'clock in the evening, si Mark ay pinagtambakan ng putok at si Mark ay nagsanhi ng pagkamatay. That crime was accomplished. Thank you, ma'am.
Good afternoon, ma'am. My name is Hannah Maika Tito
from 3BSCRIM-D. My topic is all about what are the circumstances affecting liability. First is justifying circumstances. In justifying circumstances, a person may not incur criminal liability when she or he acts in defense of his or her persons or right, provided that there is lack of sufficient provocation on the part of the person defending himself. Kumbaga, hindi siya mabilong sa criminal liability kung hindi sapat ang kanyang mga ebidensya na maipapakita sa korte. Number 2 is mitigating circumstances. In mitigating circumstances are those which do not constitute. It is intended to lessen the severity of crime or its punishment by making the defendant's conduct understandable or less blameworthy. In mitigating circumstances might include a defendant young age, mental illness or addiction, or minor role in the crime. Sa mitigating circumstances, meron na siyang criminal liability. Ang mangyayari lang ay mababawasan o bababa ang kanyang nagawang kasalanan. At kapag po ang isang requisites ay nagkulang at hindi pumasok sa justifying, ito po ay mapupunta sa mitigating circumstances. For example po, yung mga minor ding edad o 18 pababa o 70 pataas, sila po ay mapupunta sa mitigating circumstances. Mababawasan po ang kanilang mga nagawang kasalanan.
Good afternoon, ma'am. My name is Remark M. Saraos from 3rd year BSCRIM Section D, and my topic is all about aggravating circumstance and alternative and exempting circumstances. And first, I will explain the aggravating circumstances. The circumstance can be upset by or ordinary mitigating circumstance. In aggravating circumstances, habituality of reward must be primary reason or primordial motive for the commissions of the crime. Example of this: if A give a money to B as a reward if he killed C, and B is still liable of the crime. And the second is exempting circumstances. It affects the actor, not the act. My example is any persons who, while performing a lawful act with due care, cause in an injury by mere accident without fault or any attention causing it, the suspect is still liable of the crime committed. And the last is alternative circumstances are those which must be taken into considerations as aggravating and mitigating circumstance according to the natures and effects of the crime. My example is due to the lack of education or knowledge, the offender took advantage of it to commit a crime. Any person who performs this act still liable of the crime committed. And that's all. Thank you.
Good morning, ma'am. Good morning, everyone. My name is Jericho A. Vargas from 3BSCRIM-D. Now I'm reporting justifying circumstance. Justifying circumstance is ito yung circumstance na walang kaakibat na criminal responsibility or civil responsibility. Justifying circumstance are those where they act in accordance with the law. Ito yung kung gagawa ka ng isang bagay na it is justifiable, wala kang dapat ikatakot dahil hindi ka makukulong. An example dito is yung self-defense. Kunwari nasaksak mo yung isang tao dahil pinagtanggol mo lang yung sarili mo, wala kang criminal liability sa taong saksak mo. Dahil yung ginawa mo is justifiable. Ordinance with the law. Yun lang. Thank you po.
Everyone, I'm Adrian Francis C., BSCRIM 3 COCD. and my topic is justifying circumstances. Justifying circumstances are instances where a person has no criminal civil liability. For justifying circumstances to be accepted, it must be pleaded and proven in court. Philippine courts are passive bodies and only on the information is given them. Example number 1, self-defense. This includes defense of your property and rights. For valid of self-defense, you must be proved that you did not provoke your assailant into attacking you, not there was actual or imminent aggression, and the means of defend yourself were reasonably necessary. Number 2, defense of relative. Here, reasonable necessity of means actual imminent aggression will stand, but provocation is modified. That relative may be the one provoked by the attacker, but the defender must show that was not provoked by the attacker. Example number 3, defense of stranger. Once again, reasonable necessity of means and actual or imminent aggression come into play. There is not provocation here. Instead, the defender must not be motivated by hate, revenge, or any other evil motive. Example number 4, state of necessity. This is the only justifying circumstances where civil liability is present. It happens when somebody does something that causes damage to another person or his property in order to avoid any evil thing happening to himself or another person. Example number 5, fulfillment of lawful duty, exercise of right or an office. The person in question was doing his lawful duty and the injury happened while he was doing it. He must prove that he was the holder of that position when he was performing his duty. And the last example, obedience to superior order. There's a lawful order and the means to carry out are lawful. Good faith on the subordinate's part and crucial here. If honestly believed that the order was legal, he can claim justifying circumstances even if the order was illegal. That's all and thank you.
Good day, ma'am. I'm Riken Ginayon from BSCRIM-D and third year. And this is my discussions about exempting circumstances. Are those grounds for exemption from punishment because there is one thing in the agent of crime. Any of conditions which make the act voluntary or negligent, wherein there is an absence in the agent of the crime of all the conditions that would make involuntary, and hence although there are no criminal liability, there is civil liability. The insane person may be held criminally liable if act during a lucid interval. Example, analyze
Good day, ma'am. I'm Erica Janine Villamor from BS Cream, third year, section D. And today I will share to you my knowledge about the difference between irresistible force and uncontrollable fear. So, first is irresistible force. So, irresistible force is when the offender uses physical force, while on the other hand, uncontrollable fear is simply says the offender uses threat or intimidating words like that. So, for example, in a scenario like hostage taking. So, in a hostage taking, there are some um, uh, in a hostage taking po sa isang department store example, meron hong mga strangers na hindi dapat or hindi dapat kasali or intended ng offender or ng suspect na isali pero nandun na po sila sa setting. So, they will do is to use irresistible force to command those people or to um, give fear.
Good morning, Mom. I'm Glenn S. Sinat, BSCRIM-D, and this is my discussion about the difference between irresistible force and controllable fear on exempting circumstances. The, the irresistible force is the term is applied to such an interposition of human agency from its nature and power absolutely uncontrollable as the inroads of hostile army. The example of a resistible force is a man was trying to sell a shield and a spear. That is the example of irresistible force. While the uncontrollable fear is the offender's employs intimidation or threat compelling another to commit a crime. Juries used violence or physical force.
Uncontrollable fear. Hindi mapipigil na takot na gumagamit ng pananakot ang nagbabagabag o pananakot na pinipilit isa pa na gumagawa ng isang krimen. Napipigil paggamit ng karahasan o pwersang pisikal upang ito ay magiging isang wastong depensa. Dahil ito ay totoo. Napipintong o makatuwirang takot para sa buhay ng paa ng isang tao. Hindi ito dapat inspirasyon ng haka-haka, katahimikan o malayong takot. For example, kung ang isang pinilit sa ilalim ng takot sa kamatayan upang sumali sa isang rebelde, hindi siya mananagot sa paghimagsik dahil kumikilos siya sa ilalim ng salpok ng hindi pa
Good day, ma'am. My name is James Binsahan, base Scream Section D. My understanding about uncontrollable fear. Ang uncontrollable fear is ini-intimidate mo yung other person to commit crime against you. For example, yung dahil sa hindi mapigilang takot, yung dahil sa matatakutin ka, yung ibang tao ay binabiolence ka, physical at emotional. Yun yung example ng uncontrollable fear.
Good day, ma'am. I'm Jan Apostol from BSCRIM-D. This is my topic for today. Sufficient provocation as a requisite of incomplete self-defense. It pertains to itself on absence of the part of the person defending himself. Includes not only the defense of the person or body of the one insulted, but also that is the rights of the enjoyment of which protected by law. Halimbawa po, sa isang krimen, ikaw ay napagbintangan, kaya kailangan mo magpaliwanag sa kanila para ikaw ay maging malaya. Pagkos ang polis ay hindi naniwala sa iyo kaya ikaw ay ginawa nilang suspect. Provocation. Any unjust or improper conduct or act of the offended party capable of exciting, inciting, or irritating anyone.
Good afternoon, everyone. I am Joshua Vernie Kiambao from Pinma CUC Main Campus. Provision under mitigating circumstances. Mitigating circumstances, sufficient provocation. It has three elements. Provocation must be sufficient. Provocation may be defined by statutory law, by common law, or some combination. In common law, provocation is established by establishing events that would be adequate to create a heat of passion in a reasonable person, and by establishing that the heat of passion was created in the accused. Second, it must be immediate to the commission of the crime. Third, it must be originate from the offended party. Sufficient provocation as a requisite of incomplete self-defense is different from sufficient of provocation as a mitigating circumstances. Sufficient provocation as an element of self-defense requires absence of the party of the people defending himself. That's all. Thank you. Defending the party.
Good day, I'm going to report provision under mitigated circumstances. First, let me give you the definition of the three important keywords. Number one, provision. When person considered to have committed a criminal act, partially because of some situation that may cause a reasonable person to lose self-control. Example, nahuli mo yung asawa mo na may babae at napatay mo sila sa galit. Example yun ang reasonable cause of lose self-control. Sa mitigating circumstances ay reduce penalty. Ito kunwari yung babae na nag-voluntary surrender dahil napatay niya yung kanyang asawa dahil sa galit. Then sa vindication, ito yung isang act of clearing someone name. O kaya yung pwedeng example, pwede niyang malinis yung name niya dahil reasonable naman yung ginawa niya kasi siya yung legal wife.
Good morning, Ma'am Damaris. My name is Adrian Paul Guillermo from BSCRIM-D, and this is my video presentation about the provocation as a mitigating circumstances and vindication. But first of all, I want to give the definition of provocation. Provocation is one of the heat of the passion rule, and it is the most ancient defense in criminal law. Next is mitigating circumstances. It is the factor that help to lessen the guilt and encourage the judge to be more lenient in sentencing. So, provocation as a mitigating circumstances, it can be used on the court of an offended party to lessen the penalty and adjust the crime that being committed. So, example of this is A killed B because B teases A which have a mental illness. So, A punched B not knowingly, he killed B. So, it falls under the mitigating circumstances that the people have mental illness, which is the offender. So, next is vindication. Vindication, it is the meaning of vindication is proven right or you prove something. Example of this is on the trial, you prove that offender who is the one committed the crime. That's all. Thank you.
Good afternoon, ma'am. My name is Raymond M. Odasco, 3BS Criminology, Section D. The explanation, generic, aggravating circumstance, generic, that which generally applies to all crime, like recidivis, specific, that which apply to all particular felony, like cruelty in crimes against person. For example, generic, aggravating circumstance is recidivis. Ang recidivis ay isang bilanggo na pinakawalan, ay isang kriminal na pinakawalan sa bilangguan. Ay ngunit gumawa siya ng isa pang krimen. Ikaw ay isang warden sa isang maximum security na bilangguan. Ang sa Kingston at nais mong matukoy kung aling sa mga bilanggo ang maaaring maging recidivis. Sa kabutiang palad, mayroon kang isang degree na crime. Kaya gumawa ka ng diskarte na hinihimok ng data. Nakolekta mo ang ilang makasayang ng data na nagsama sa ilang pangunahing metadata at kung ang bilanggo ay natapos na maging recidivis o hindi. That's all. Thank you.
Our topic is generic aggravating circumstances. What is aggravating circumstances? Aggravating circumstances is based on the higher degree of perversity of the offender at the time of the commission of felony. Generic aggravating circumstances is one of its kinds. It generally applies to all crimes, like recidivism, which means the tendency of convicted criminal to reoffend. One of the examples of aggravating circumstances that increase the severity or culpability of criminal act that lack of remorse or remorseless. It is a person that has no any guilt or even he did something terrible. Next topic is the by the band. If a crime committed by the band, it means that there are 3 or more armed malefactors or person that act together in making the offense. The example for this is the like robbery. When you plan something in the beginning until the end, you act together as one to execute every plan you settle.
Good day, ma'am. I am Christy Marie Viquilia Valeroso from BSCRIM-D. Now I will be going to give a brief explanation and give an example of the qualifying aggravation circumstance and paragraph 8 with aid of armed men. First is the qualifying aggravation circumstance. Ito po yung this circumstance affect the nature of the crime. Also, it changes the crime to a more serious crime. Halimbawa po dito is yung when you commit a homicide. Mas mapapalitan ito sa mas mabigat na crime. For example, murder. The next one is paragraph 8. With aid of armed men. Ayon doon, there are at least 2 armed men. Sila po yung mga kasamahan ng offender sa paggawa ng isang particular na krimen. Ngunit hindi talaga sila yung pumatay or kahit sila lang yung tumutulong sa offender sa paggawa ng krimen. Halimbawa dito ay John killed Mike. However, Jay and Albert helped John to hide the dead body of Mike for them to be able to para para makatakas sila sa isasampang kaso sa kanila, kaya nila yon ginawa na i-hide yung body ni Mike. That's all, ma'am. Thank you.
Good afternoon, I'm Michelle Valencia. Ang aking topic is qualifying aggravating circumstance. Ang aggravating circumstance ay ito yung isang pagpapaalala sa mga nangyayari na sa isang krimen. Example is, may isang krimen na ginawa, kunwari pagpatay, pero ibang ipaparatang na kaso dahil sa mga tao o sa mga titistigo, sa mga nag-imbestiga ng kaso na yun. Papalitan ng mas malaking kaso kumpara sa pagpatay lang. Dadagdagan kunwari ng katulad ng pagtangkang pagnanakaw para mas lumaki yung kaso niya. Kasi sa nature, dito nakapaligid yung mga pinangyarihan ng krimen. Kunwari may nakasaksi or may nakakita na pumasok sa ganito or sa ganun, sa ganyan, siya yung huling nakita doon, siya yung huling nakita sa mga pinangyarihan ng krimen. Siya yung magiging suspect kasi nga siya yung last na nakita sa krimen na yun. Isa pang example is iniiba yung kaso tukoy sa mga titistigo, hindi iba ng batas ang pinangyarihan. Kasi di lang iisa yung dahilan, hindi lang iisa yung nakitang dahilan sa mga nangyayari sa isang bahay. Yun lang, thank you.
Good day, ma'am. Good day, classmates. I am Arnel Nicol James K. Tagod from Section D. Today, the topic that I discussed for today is that our video assignment topic about recidivism in Article 14, Paragraph 9. In this topic, pag-usapan natin ang 4 na uri ng repetition. Una, pasok na po dito ang recidivism, quasi-recidivism, habitual delinquency, at ang wakas ay reiteration. So, para sa atin, ano ang ibig sabihin ng recidivism? Para po sa akin, pag sinabi po na recidivism is the tendency of convicted criminal to reoffend. So, who is the recidivist? A recidivist is one who hit time of his trial for one crime shall be previously convicted by final judgment of another crime embraced in the same title of the code. It has the effect of aggravating the penalty. It is maximum period. So, ang explanation po dito ay when we say recidivism, ito po ay magkaparehas na titulo. For example, for Revised Penal Code Title 10, crime against property. So halimbawa nagnakaw po ako ng bilyong halagang pera, tapos natulan po ako sa korte ng final judgment na robbery at nakulong ako ng ilang taon, at pagkalipas ng ilang taon ay nakalaya ako. Tapos
Good morning, ma'am. I'm Edwin Liga Jr. from 3BSCRIM-D, and I will explain the meaning of reiteration. Reiteration, where the offender has been previously punished for an offense to which the law attaches an equal or greater penalty for two crimes to which it attaches an equal or lighter penalty. This is a generic aggravating circumstance. Reiteration. Hindi kino-consider ng batas na magkaparehas yung title na nagawa mo as long as na nakagawa ka ng crime na magkaibang titulo. Ito ay tinatawag na reiteration. Halimbawa, yung crimes against person. Nag-commit ka ng homicide, napatay mo po yung tao, tapos nakagawa
Hey everyone, I'm Edison Ramos from 3BSCRIM-D. Let's talk about the reiteration. Reiteration is, ito ang pagkakasala na paulit na nagkakasala. For example na lang, nagnakaw ka na nung isang araw at kasunod pang araw ay nagnakaw ka ulit. Number 1. It's necessary is the offender shall be served out his sentence for his first offense. Ito ang nagkakasala na maghahatid sa kanyang kaparusahan sa unang pagkakasala. For example na lang ito, ang lalaki ay kung ano ang una niyang ginawa sa pagkakasala, yun ibabase ang kanyang kaparusahan. Katulad ng pagpatay ng tao na mahatulan siya ng habang buhay na pagkakakulong. Number 2. The previous subsequent offense must not be embraced in the same title of the code. Ito ang pagkakasala na hindi kapares ng kaparusahan. For example na lang, lamang yung pagpatay ng habang buhay na pagkakakulong at yung pagnanakaw na ilang taon na pagkakakulong. Number 3. Not always the aggravating circumstances. Ito ang sa lahat na pangyayari na hindi maluba ang pagkakasala. For example na lang, ang lalaki nakapulot ng pera na ibalik niya ito sa may-ari pero may nakuha siyang unting pera sa wallet. Number 4. Rationale is the proven resistant to rehabilitation. Ito ang pangangatwiran na nagawang pagkakasala. For example na lang, ito yung nahuli ka na sa pagnanakaw pero itatanggi mo pa na hindi mo naman ito ginawa.
I'm Sheila May A. Umabaw from 3BSCRIM-D. I'm going to discuss delinquency. Delinquency, criminal behavior, especially carried out by a juvenile. It is thus distinguished from a status offense, a term applied in the United States and other national legal system, to act considered wrongful when committed by a juvenile but not when committed by an adult. Depending on the nation of origin, a juvenile becomes an adult anywhere between the ages of 15 to 18. Although the age is sometimes lowered for murder and other serious crime. Ang delinquency ay nagpapahiwatig ng pag-ugali na hindi umaayon sa pamantayan ng legal o moral ng lipunan. Kadalasang nalalapat na lang ito sa mga kilos na kung isinasagawa ng isang may sapat na gulang. At tatawaging kriminal sa gayon, ito ay nakikilala mula sa isang paglabas sa katayuan. Isang term na inilipat sa Estados Unidos at iba pang pambansang legal
na mga sistema sa mga kilos na itinuturing na mali kapag ginawa ng isang bata, ngunit hindi kapag ginawa ng may sapat na gulang. Example of delinquency is stealing from a store. Ang pagnanakaw ng mga bagay mula sa isang bukas na pagbebenta ng tingian, karaniwang sa pamamagitan ng pagtatago ng isang item sa tindahan, isang tao sa mga, kunyari magnanakaw sila, ilalagay nila sa bulsa, sa ilalim ng damit o sa isang bag at iniwan ang tindahan na hindi pa sila bayad. Thank you po.
Good afternoon, Ma'am Damaris. My name is JONALYN 3BSCRIM-D. This may report about habitual delinquency. A person is considered as a habitual delinquency if within a period of 10 years from date of his last release or conviction of the crimes of serious or less physical injuries